Yeah.
Is his attorney here? All right, Mr. Butler, if you'll come forward. So counsel, on this case, you have all the discovery? Okay, and has an offer been tendered?
I haven't had a chance to, I was just appointed last time.
Okay,
So we haven't had a chance to visit with her.
okay. All right, Ms. Ferguson, recall this back for June 10th.
Brown.
What page is Brown on?
Oh, yes. The Valentina Koga.
Oh, she's supposed to come back and let us know if the bondsman agrees to be on his bond. If he does, then what's going to end up happening, I'll reinstate his bond.
She sent me a text.
All right, so I'll let her know that's the appropriate question.
No, I'm not hanging out.
I'll see you before. I'll see you. Crap.
Oh, it's Darren Johnson. She's on bond.
Okay.
Family violence. We're going to start with jury selection, take a break, and then we'll come back and finish. Thank you. Yes. No, we're going to take a break after I do my part. Yes. Yes.
Confused.
Thank you. I'm sorry. Okay. You're welcome. Mhm. Do you need something?
Are you in this trial too?
Okay, sure. What's up? Just 1
It'll be
second.
right next to you. No, she's right there.
And if she were found guilty, are you going to the court or jury for punishment?
That's my part,
Okay, no problem. So is she eligible for probation? Have you all filled out the documentation or no? All right. And could I see the file on Darren Johnson, please?
Oh, Ma'am, where are you? Right here. I'm the. Right here, ma'am. Here. Oh, go sit down right here. Okay.
Look, that's the final. Thank you.
Thank you.
Written on it inside.
Thank you.
There's something we
All righty, thank you. And Deputy Laura, I know that Yaya says there are some people she needs to swear in. Next door is available. Is there anybody-
You guys are about to start with somebody else, right? Yes, I get to talk to the judge about. She'll probably bring you back. But there's an offer in there. Yes.
Oh, I'm waiting for them to give me word back. All right, so everyone. Oh, State, I don't know if you want to keep those boxes there. Because we're doing jury selection. All right, thank you. And then you all, it takes me usually about 30 minutes, so we're gonna take a break in 30 minutes. And then if you all will go next door, the deputies are gonna see if they can swear in whoever they can swear in. And then they'll have your client brought out as well.
You there?
Yes,
So I can control my contact.
yes, they're gonna see if they can make that happen.
Do we stay here, Greg, or go outside in the hallway, and wait, or?
You can go outside in the hallway if you'd like and
Thanks.
go next door and see if Deputy Laura is able to do that for you.
You can leave. Yeah, if we don't get it, just, I file.
Mhm. We shall see. Yeah, okay. Oh, no problem.
I like the we shall see.
We shall see, yeah. All right, the court is calling. Oh, and Cindy, did you make sure that all of the attorneys have their,
I've got them, they're putting out there. Oh, yes.
yes, their squares?
Yeah.
Yes.
All right. Court is calling 2024 CR 2675 State versus Darren Johnson. Can I have parties announced for the record?
Megan Galloway and Andrew Edelman, state.
William Davidson, Robert Porter for Ms. Johnson.
All right, and are you Miss Johnson?
Yes, Your Honor, I am.
All right, are both parties ready to proceed?
Yes, Your Honor, state's ready.
Yeah, this form. If you want, not to-
All right, thank you.
Just sign these two pieces of paper. One's an application.
Yes.
She refuses, so.
All right, let's bring the jurors in.
Ready?
Yes.
Oh, excuse me, State. Yes. Are you all proceeding on both counts?
Yes.
And both counts are aggravated assault?
The second count is injuries to health.
Okay, as of,
Correct.
all right.
I would ask the action. Over the line. Ready? All rise for the jury. First row on the seat, it's number 1. Yes, in the first row. All the seats are numbered. Number 8, second row. Keep bringing them. 15. Just hold the door, Cece, just hold the door. And just have them come in. 15
15.
on the bench. 22.
Oh,
Next row.
I'll see you all briefly. All right, good afternoon, ladies and gentlemen. Okay, that is just such slow non-reaction. I'm trying to make sure everybody's wide awake. So, good afternoon, everyone. All right, now everybody knows that everybody's awake. That's a good thing. All right, so you are here for a jury trial and you are on the 4th floor, the 187th District Court, and I'm Judge Boyd. So what floor are we on? What's the court number?
187.
Who's the judge? See, everybody trailed off on that part. Like when you sing Old Lang Syne, everybody's voice is up here. Then when you get past that first couple of lines, you just go down. The reason why I asked you that question is because sometimes we're going to take breaks. And when we take breaks, that doesn't mean you're excused. It just means that we're taking a break. And whenever we take a break, everyone has to leave the courtroom. Sometimes we'll start jury selection, we take a break, and we have to search for a juror, and that juror's gone missing. They will come back after we found them. They say, I looked up, everybody was gone. I didn't know where to go. So if you are ever on a break in this court and you look up and everybody is gone, all you have to do is ask for the 187th. There's only one 187th in all of Texas because it was the 187th District Court that was created. If you can't remember that, if you just remember the last name Boyd, I'm the only Judge Boyd in the entire courthouse. So someone will be able to direct you where you need to go. To my left is the court reporter. Court reporter takes down everything that everyone is saying. I always said if I was ever in a position to make someone's job easier, I would. So this is how we can make her job easier. If we all remember to speak one at a time, she can probably take down 3 people talking at once, but let's not do that to her. So let's wait. I know it's easy to get involved in conversations with people where you anticipate what somebody's going to say, so you speak over them. So let's not do that because that will make it easier for her to hear everybody and to write everything down. Now, in your possession, you have something that is priceless. And I don't mean photos of your children, but other than that, something that is priceless. Those are those cards you have with you. So we're going to make the court reporter's job easier. Does everybody agree to do that? This is how we can do it. Everyone raise your cards. Do not lower those cards until I tell you to lower the cards. Whenever someone is speaking, if you have a question, juror number 15, raise your card. If you have a question, raise your card. Someone will acknowledge you by your card number. Once they acknowledge you, then you can speak. So, jurors 1 through 21, lower your cards. Everyone else, have an added job for you. The acoustics in this courtroom is not great. Believe it or not, people near the back row, the court reporter will not be able to hear you unless you speak in the tone that I'm speaking. And also, it would help if you will stand whenever you have a question or someone addresses a question to you or you have an answer. Everybody raising your cards now. Will you be able to remember that and stand if you have something to say?
Yes.
All right, I have great faith in you, but so far no jury has been able to follow that rule. And we're in jury trial every week. So that's been since 2019. So do the math. But I'm going to tell you what I tell them. I have faith that you all will be able to follow that instruction. All right, you can lower your card. This is the state of Texas versus Darren Johnson. I'm going to have the parties introduce themselves to you. State.
Good afternoon. My name is Megan Galloway and I represent.
Andrew Harris Sadelman, assisting Galloway.
Hi, I'm William Davidson. I represent Darren Johnson.
Good afternoon, ladies and gentlemen. Robert Porter. Good afternoon, John.
I'm Darren Johnson.
All right, thank you. So raise your card if you recognize any of those parties or know any of those parties. All right. Now, the next thing I want to talk to you about is the charge in this court. So Ms. Johnson has been accused by indictment with aggravated assault with a deadly weapon in count 1, and count 2 is injury to the elderly. Now, when the state talks to you, when the defense talks to you, they're going to be talking to you about hypotheticals. Neither the state nor the defense can tell you what they think the facts of this case are. Does everybody understand?
Yes.
So whenever they ask you a question, don't be like Mrs. Kravitz from Bewitched and say, oh, that's what this is about. They're not allowed to tell you what this is about. The only thing they can tell you is this is what the person is charged with, so they can get some idea on your feelings about certain things. Does everyone understand?
Yes.
Now, I want to talk to you about indictments, because with indictments, people always say, oh, what is an indictment? What does it really mean? So let me just tell you legally what it means. It is just a piece of paper, and it's to let the person who is being accused know what they're charged with. It is not to be considered as evidence by you. It cannot be used for anything. Does everyone understand?
Yes.
For example, how many people here have had a traffic ticket? Let's practice raising our cards. Now that I will tell you, since 2019 has always been the same. San Antonio is filled with bad drivers. So you can lower your cards. Now, when you receive a traffic ticket, and I've had a traffic ticket before when I was, I think, about 19 or 20. So that was just about 2 years ago. So, hey, there shouldn't be much laughter. It should be, oh my gosh, we can't believe how young you are. But at the time I got my traffic ticket, that was when the officers had the paper books and they would write your ticket and then give you a copy of the ticket. And now my understanding, they do it electronically. So let's say an officer pulls you over in Bexar County. And the reason why they pull you over is because they say that you were going over the speed limit in a school zone. I'll use that as an example because people don't seem to know that the speed limit is 20 in the school zone. So let's say you're going 30 miles per hour in a school zone. That's what the officer says, right? So the officer pulls you over and the officer gives you a ticket. On that ticket, it's going to say, I'm saying you were going faster than 20 miles per hour in a school zone. When you accept that ticket, you're not saying, oh yeah, officer, you're correct. I was going over the speed limit. That ticket is just to let you know, this is what the officer is saying you did, and this is where you need to go to answer for that ticket. And usually it will be in municipal court on Frio Street. And when you get to the court, that ticket doesn't mean you're guilty. It's just to let you know what you're charged with, because it would be very strange if you were to show up to Frio Street and you think you're showing up because an officer is saying you were speeding, and surprise, you're sitting before a jury and all of a sudden you find out they're saying you ran a stop sign. So with indictments, they are not evidence of anything, and you cannot take them to mean anything. It's just to tell a person what they're being accused of. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Miss Johnson because she's been indicted? If you are, raise your card. All right. Now, the next thing I want to talk to you is about certain rights that people have. One of them is the right to remain silent. Has everyone heard of that term before, or those words before?
Yes.
All right. So anyway, what does that really mean? What that means is, in criminal cases, you don't have to testify. The state can't call you as a witness. You don't have to testify if you don't want to. Now, I've been a defense attorney. I've been a prosecutor. There are several reasons why someone may choose not to testify at their criminal case, right? Sometimes people are so terrified, they're sweating. And what do people say? Oh, you can judge whether somebody is telling the truth. And then people will say, Oh, are they sweating? Do they look to the left? Do they look to the right? And then sometimes people have speech impediments. And then sometimes attorneys will tell their client, you know what? The state didn't prove their case. There's no reason for you to testify. So there's a host of reasons why people would choose not to testify. Does everyone understand?
Yes.
Now, when I'm out with people at dinner or when I've done voir dires before as a defense attorney and a prosecutor, there is always somebody in the crowd who says, well, if that were me, I would want to tell my side of the story. And I would always have to pull myself back as a defense attorney and as a prosecutor and say, but it's not you. And you don't know what you would do in that situation because you're not in that situation. It's easy to say, you know what? I would stand up and say what I needed to say. That's easy to say when you don't have to do it. So the main thing about the right to remain silent is everyone in the United States who's charged with a criminal case has a right to remain silent. They don't have to testify if they don't want to testify. And the law says you can't hold it against them if they choose not to testify. So if someone decided not to testify, you can't be deliberating and say to yourself or say to other jurors, you know what? That's a strike against them because they didn't testify. Or, well, it would have been great to know how they felt about this or their side of the story. You're not allowed to do that whatsoever. You're not allowed to hold it against them. Does everyone understand? Is there anyone here who cannot do that? If you cannot, raise your card. All right, the next thing I want to talk to you about is presumption of innocence. What does that really mean? It means that everybody who's charged with a criminal case is presumed to be innocent unless and until the state proves their case beyond a reasonable doubt. And usually how states prove cases beyond a reasonable doubt is they prove it by calling witnesses or presenting evidence. Does everyone understand?
Yes.
So right now, how much evidence has been presented to you? So if you had to vote right now on whether Ms. Johnson is guilty or not guilty, what should your vote be? Okay, see, some people are not answering because I only heard about 10 people. So I'm going to ask that question again. If you had to vote right now on whether Ms. Johnson is guilty or not guilty, what should your vote be?
Yes.
All right, is there anyone here who feels differently? If you do, raise your card. There's no right or wrong answers here. Everybody just wants your opinion on things. All right, so the state has to prove its case beyond a reasonable doubt. They have elements to a crime, and they have to prove each of those elements beyond a reasonable doubt. Usually they got to prove when it happened. They got to prove that it was in Bexar County because we're in Bexar County. They have to prove the parties involved. They have to do all of that beyond a reasonable doubt. Does everyone understand? Yes. All right. So they have to prove that beyond a reasonable doubt. What is beyond a reasonable doubt? When I was in law school, you had to learn that definition. I knew that definition forwards and backwards. I knew where to do the exclamation point on that, and I knew where to pause for dramatic effect. See that pause? Well, once I had my first jury trial, guess what? After that, when we were sweating it out in law school, trying to memorize that definition forwards and backwards, there is no longer a definition for proof beyond a reasonable doubt. So when I was a defense attorney and a prosecutor, I had to figure out how to explain that to jurors then, because we don't have a definition. So this is how I would explain it to them. Next door, the historic courthouse with the green rooftop, they try civil cases over there. Anytime you have cases over there that deal with money, right? Normally, their burden of proof is preponderance of the evidence. More likely than not, something happened. If you're ever deliberating in a criminal jury trial, be it misdemeanor court or felony court, and this is a felony court, and you're in the back deliberating and you're saying, I think this happened more likely than not, you are not at the correct burden of proof. And that deliberation is not correct. Does everyone understand?
Yes.
The other burden of proof they have over there, which is their highest burden, is clearing convincing evidence. And clearing convincing evidence is the type of evidence that is used to say, you're not a good parent, you're a danger to your child, so we're terminating your parental rights and you will no longer parent this child. Now, that's a high burden, but there's a higher burden. The highest burden we have is proof beyond a reasonable doubt. Does everyone understand? Now, the next thing I want to talk to you is about fairness and what does that mean? All right, this is what the hypothetical that some people would give you. They would say, you're getting ready, you know you're going to have jury duty, you map out that you're coming downtown, you've made arrangements, and when you come downstairs, you go into your driveway and your car is on cinder blocks. Somebody has taken the radio, somebody's taken the tires, but you're doing your civic duty. So you call an Uber or Via after you report that your car is on cinder blocks to the police, and you come down to the courthouse and you're waiting outside, waiting and waiting and waiting. And then you're finally brought in for jury duty and you find out that the case that you're going to hear is where someone is accused of burglarizing a vehicle. And then people will ask you, so can you be fair with that? That's really not the appropriate question. The appropriate question is whether or not you will be able to listen to whatever evidence is presented to you and make a decision if you can reach a decision based upon that evidence, or if you're going to say like, you know what, my car just got burglarized. This person is accused of burglary of a vehicle. I don't care if the state proves its case or not. I'm just going to find this person guilty because my vehicle got burglarized. This is what I tell everyone. Is there anyone here who was born last night? I'm sorry, is there anyone here who was born yesterday and slept all last night? There's nobody here like this. Everybody that is walking around has had maybe something bad happen to them or some trauma. The question becomes, will you be able to be fair in this case? And fairness in this case means if you are placed on this jury, will you be able to listen to the evidence? And if you're able to come to a decision, your decision be based upon the evidence that's presented to you. Does everyone understand?
Yes.
Is there anyone here who cannot be fair? Is there anyone here who cannot listen to the evidence and base your decision, if you can come to a decision on the evidence that's presented to you in this courtroom? Is there anyone who can't do that? All right. Now, the next thing I want to talk to you is that there are two phases to a trial. The first phase, people call it they call it the innocence phase, but it's really not. The first phase is where you hear evidence. And the question becomes, did the state prove their case beyond a reasonable doubt or did they not? It's not, did the person prove their innocence, because they don't have the burden. The issue is, did the state prove their case beyond a reasonable doubt or did they not? If the state doesn't prove their case beyond a reasonable doubt, what should your verdict be? Okay. And then if they prove their case beyond a reasonable doubt, what should your verdict be? All right. So that's the first phase. Now, if the state doesn't prove it, it's not guilty, there's no phase two. If they prove their case, then it would be guilty, and there's what's called a phase two. And phase two is called the punishment phase. Does everyone understand?
Yes.
So in punishment, what ends up happening is you'll listen to whatever evidence that's presented, if evidence is presented, and you'll be called upon to make a decision on someone's punishment. In this case, count one is aggravated assault with a deadly weapon, and count two is injury to the elderly. So the range of punishment for count one is anywhere from 2 to 20 years in prison. Count two, anywhere from 2 to 10 years in prison, right? And as you can see, that's a wide range of punishments, right? 2, 3, 4, 5, all the way to 20, 2, 3, 4, 5, all the way to 10. But there's also the possibility of probation. Now, people will always ask, well, I don't know if I were to find somebody guilty of this, I don't know if I could give them probation, or I absolutely couldn't give them probation. I need more facts. That's what jurors always say. Well, I need more facts. You're not going to get any facts unless you're on the jury. Does everyone understand?
Yes.
So the question becomes, I have told you what the range of punishment is. Does everybody understand the range of punishment?
Yes.
So there's a possibility for probation if you were to find somebody guilty of these charges. And there's also the possibility of up to 20 years. Does everyone understand?
Yes.
So the question becomes, can you consider the full range of punishment? That's my first question. Is there anyone here who could not consider the full range of punishment? All right. Then my next question, is there anyone here for religious reasons or some sort of internal reasons where they cannot pass on they cannot give punishment? Is there anyone? All right, number 72. All right, you can lower your card. Thank you. And I'm sorry, the proper term is pass judgment. All right, so the next thing I want to talk to you about is languages. I love languages. I'm originally from Louisiana. So when I was in school and we had a choice of languages to take, I knew I would be retired at 21. And again, here I am, 22 and not retired. And I knew I was going to retire to Paris. So of course, there was only one language for me. I'm in Louisiana. We have French speakers. My friend begged me, Stephanie, take Spanish with me. And I said, never going to have to use it. So I'm going to stick with my French. And here I am due to school in Texas. And I call her all the time and I said, should have listened to you. So I'm working on my Spanish language. So is there anyone here, raise your card if English is not your first language? Please raise your card. And when I call out your number, you can lower your card. Number 4, 13, 14, 22, 37, 48. All right, juror number 4, what is your first language?
Spanish.
All right, have you been able to understand everything?
Yes, ma'am.
Juror number 13, what's your first language?
Yeah.
Have you been able to understand everything? Thank you. Number 14, have you been able to understand everything? Juror number 22, we're testing. Don't fail me. All right, we're gonna pretend like that didn't happen. All right. Guys, tap the person next to you. I want you guys to succeed at this. All right, juror number 22.
Spanish.
Have you been able to understand everything?
Apparently not everything.
All right. All right, we're gonna start over from ground one. So we're gonna pretend like that didn't happen. Juror number 37. Okay, Ibu, this is the first time. How do you say hurry up in Ibu? All right, I'm gonna work on that. Have you been able to understand everything? All right, thank you. Number 48.
Tagalog, Filipino.
All right, have you been able to understand everything?
Yes, ma'am.
All right, thank you.
Thank you.
Now, the reason why I asked you, how do you say hurry up? Because the students that I went to school with, usually my classmates from the Middle East, they speak no less than 5 languages. And then they were able to teach me something. And what I was able to remember is I can say hurry up in almost every language, but that's a new one for me. So I'm going to learn how to say that. All right. The next thing I want to talk to you all about is travel arrangements or time constraints. I believe this trial will be concluded by Friday. So does anyone have any type of travel arrangements or time constraints? Please raise your card. And once I call your number, you can lower your card. 5, 6, 7, 10, 17, 21, 35, 40. I can't see the person behind you. 42, 44, and 69. All right. Juror number 5, what's your time constraint?
Oh, that's great. It's for me, I have to catch the bus across town.
Okay.
So it'd be kind of difficult for me to get up early in the morning just.
What's your bus number? I used to ride the bus.
I have to catch, it was a 6:32 from Windcrest,
Okay,
from over here. It takes an hour and a half.
all right,
And I have to catch like.
all right, thank you. Number 6,
I have a trip this weekend. I have to go to Los Angeles for business, also for my daughter's birthday.
all right, when's your daughter's birthday?
Well,
Oh, tell her I said happy birth month.
I will.
But-
You'll be in touch one day.
Oh, that'll be awesome. She should come by and visit. Okay, so the trip for the job, when is that?
Each Sunday.
Sunday. And what are you doing?
I'm a music producer.
And who are you producing?
Multiple artists.
And who would those artists be?
Well, you want me to say or?
I'm asking questions.
Oh, well, some of them are various like solo artists and some of them are band.
Okay. It's under wraps. It's a secret. Okay. All right, juror number 7. And what are you doing in Portland on Saturday? All right, have you already RSVP'd? Do they want you there? Did you get your gift? Are you registered? Okay, all right, thank you. Number 10? Yes,
I do not work or live here in Texas. I work and live in Mexico.
all right, I'm gonna ask you what they probably should have asked you downtown. Did you check, downstairs? Does your license reflect that?
No, that's what I need to.
So then you're still a resident here. Okay. All right. Thank you. Number 17.
I have to attend my mother's, she's graduating college on Thursday,
Oh, where is she graduating from?
Northwest Vista.
Did you get her a gift?
Yes.
All right. You need to get her a gift in flowers, okay?
Yeah.
So what day is she graduating?
Thursday at 10 a.m.
All right, thank you. Tell her I said congratulations. All right, 21.
It's my firstborn's graduation, his high school senior. And I wanted to partake in his senior events this week, which has pictures, breakfast, travel arrangements, and it's just all week. He graduates June 7th.
Whatever happened to seniors just taking photographs at Olin Mills? And it's
That's exactly
$2.50.
what my aunt said, but it's just been a long journey with him and I just wanted to partake in everything I can with him.
All right, awesome. And so when does this all start?
It's actually senior breakfast is tomorrow morning with pictures and then the walk of graduation.
Do they still do a baccalaureate?
No. It's all different now,
Okay. All right, thank you.
of course.
And tell them congratulations.
I appreciate it.
Number 35.
My wife is 37 weeks pregnant and the OB said that she might be early. So it could be like any day.
All right, are you going to be there to help or are you going to just be there to pass out?
Maybe a little bit at first and then. It's like-
All right, thank you. Number 40.
My grandmother's moving back to my hometown. I was going to go help her move over there.
All right, and where is the hometown?
Rosenberg, Texas, by Houston area.
All right, thank you. Oh, I'm sorry, when is the moving date?
This Friday.
All right, thank you. Number 42.
I'm a school counselor in Northeast.
Mhm.
Thursday's the last day of school and they're moving to campuses, so I won't get to say bye to my kids if I'm not there.
All right, so the last day of school is when?
Thursday,
And what were you saying after that?
that they're switching to campuses next year, so the kids that are there now, this will be my last couple days with them before they switch to campuses.
Okay, all right, thank you. Number 44.
I got custody of my grandson, so I gotta make sure that he gets to the bus.
And how old is your grandson?
He's 12, but where he walks, I gotta make sure that he gets there.
And when is that?
But that's every day that he goes.
I'm sorry, what are the hours? I mean, I'm sorry.
The hours, it's at 6 o'clock in the morning.
All right, 6 a.m. in the morning, and when else do you need to be there?
I don't need to be there. I make sure that he gets, I called him to get up and he could walk there, make sure that he gets over there.
All right, thank you.
I'm at work.
Okay. All right, thank you so much.
Yeah.
Number 69.
Michigan on Friday.
I'm sorry, what?
A walk trip to Michigan on Friday.
And what type of work?
I am a compliance manager.
Okay, what does that mean?
It means that I make sure that organizations are doing the right thing, following rules and regulations, and I do have a certification.
Okay, I'm sorry, you need to keep your voice up for the court reporter.
Sorry. Compliance, I pretty much make sure that the organization I work for, National Alliance on Mental Illness, so I do have a presentation for our state organization and affiliates in Michigan. Right?
All right, you're not going there to fire people, are you?
No.
All right,
I
because
don't
if
have
so, I'm going to make sure that you stay here. I'll help them out. All right, thank you. All right, I'm going to give you all a short break. After I finish with my part of voir dire, then I'm going to turn it over to the state and the defense, and I'm going to give you that short break, because there are a couple of matters that I need to take up, not involving this case, all right? So I'm going to tell you all two stories. Both of the stories are true. I know that jury duty is an inconvenience. It's an inconvenience because you have to be here at 8 a.m. I see everybody running, and I always tell them, slow down. It's hurry up and wait. But they don't listen to me because, it's like, what do you know? We need to be here. And then when you get there, you're waiting. And then once you've been given questions down there, then you wait for another court to call you up. Then you get called to a court and you have to wait outside on the gorgeous hallways, and there's not enough seating. And then when you're trying to get downtown, there are a lot of one-ways that nobody tell you about. Then you're trying to find parking. I always tell people it's an inconvenience because your country only asks two things of you: pay your taxes and come down for jury duty once in a blue moon. So raise your card if you've ever served on a jury trial where you listened to evidence. Now, that holds true. So the government doesn't even ask you to come out every 2 months. It's just really once in a blue moon. So I always tell people, this is a sacrifice. My family grew up in Grand Cane. And when I say my family, I mean my mother, my grandmother, my uncles, and my aunts. So my uncle was super intelligent. And that was when all the teachers knew all of their students and they knew all the family. They used to call my mother and her sister the Lane girls because everybody knew them, right? So he would get passed to different classes because the teachers would tell my grandmother, we've taught him all we can teach him. And so he ends up getting close to graduation. And of course, the siblings are not feeling so great about him because the teachers tell them, we're expecting a lot out of you because he set the gold standard. So you all better be intelligent as well. So he ends up graduating. And when he graduates, there's something that occurs called the Vietnam War. And my grandmother has to sign for him to go. He tells my grandmother, civil rights, everything that's going on, I'm not going to be able to prove my lot here. So I'm going to join the military. So parents always say they don't have a favorite child. But the firstborn, there's something special about the firstborn because you're basically practicing on the firstborn, right? So that's her firstborn. She signed for him to go. And that was a sacrifice because young people, my grandmother, she did have a phone, but it wasn't a rotary and it wasn't a touch tone. And young people are like, what's a touch tone? What's a rotary? My grandma's phone didn't have any numbers. You pick it up. When you pick it up, the operator answered and you would tell them what number you wanted called. That's why you would have songs like Beechwood 45789, because that's what number you want. Operator, could you get me Beechwood 45789? They had a television set. First, they had the radio. And the radio, you just had the giant battery. And my mom would always tell these stories where they would sit around and listen to shows like My Gal Sunday. Then they were able to get a television set. And when they got a television set, it only had 3 stations: ABC, CBS, and NBC. And you really couldn't count on NBC because the weather had to be perfect. Otherwise, you'd end up with lines. And all of this thing, young people and other people, where you have 24-hour news cycle, they didn't have that. Guess what? The programming would end at a certain point and they would play the national anthem. That's the end. No computers, no sending off an email, no picking up a cell phone. She didn't have any of that. All she had was his name and his number and where to send the letter. And wait until the letter came back. My grandmother quickly learned you don't want people in military uniforms come knocking on your door because that's bad news. So to me, that's a sacrifice. And I used to end this story at this point, but then staff would say, like, Judge, you didn't tell them what ended up happening. People are like, what happened to your uncle? What's going on? My uncle has since passed, but he made it back. My grandmother has since passed, and some of the siblings have since passed, but he made it back. But I always tell that story because I want to remind people that's what a sacrifice is. Many times you have Independence Day, Memorial Day, Veterans Day, everybody waving their flags during their cookout, cooking their barbecue. But then when it comes to your country to say, hey, thanks for waving the flags, but what we really need you to do is once in a blue moon, come down to jury duty. People will be like, let me try to get out of that. But this is all your country is asking of you. You don't even have the draft anymore unless something changed. So you're not even asking to go off and fight a war. They're just asking for you. And the state is asking of you. Defense and Ms. Johnson are asking of you to be active listeners, to sit on a jury if you make it to the jury and listen. Is there anyone who can't do that? Next story I'm going to tell you is about my friend that I went to law school with. She decided to do civil law. No shade to civil attorneys, but they're not usually not in trial a lot. So she comes up for jury duty. She said, Stephanie, can we have lunch? I'm like, yeah, sure. We have lunch. I asked her, how is jury duty going? She's like, oh, it's going fabulous. Like, how can it be fabulous? It's not with me, but okay. She said, it's going fabulous. I'm like, what do you mean? She said, it's like in law school. I'm on the back row. I got my head down. I'm not asking any questions. I start laughing. She say, what's so funny? I tell her, it's going to be great because I'm going to get to have lunch with you all week because you're going to be on the jury. So other than waving your card and saying, please select me for this jury, the quickest way to end up on a jury is not saying anything. And I tell you all this because the state and the defense are going to each have 30 minutes to talk to you. They're not going to be able to sit down, have dinner with you or any of that. In those 30 minutes, they're going to have to make some decisions. So make sure that you speak with them, okay? So with that being said, I'm going to give us a short break because I have to take up 2 other matters outside your presence. It's unrelated to this case. It's just something from the morning docket. So you all know where the restrooms are. Look to your left, look to your right. Look to your left, look to your right. You're responsible for that juror being in line. All right, and I'm going to have you all come back at 2:50. Everyone, please rise for the jurors.
Don't take the numbers, please. Come get
Please leave the numbers.
It goes next, I don't know. Please don't take the number.
All right, Mr. Brown. Hello. Okay, let me just tell you what's gonna, who is the prosecutor? Can I see the file on Brown, please? And Denny, I'm calling them as soon as they give them to me. All right, court is calling 2025 CR 001 and 990 State versus Amelia Lopez. Can I have parties announced?
Ashley Jones for the state.
And are you Mr. Lopez? Counsel, you received all discovery. Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Attorney for the state of Texas, and yes, we are, Your Honor.
Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with burglary of a habitation. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison with a possible fine up to $10,000. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. State is silent on your application and there's to be no contact with the complainant. Did you understand that to be the plea? Defense, is that the plea? State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State office and evidence, which is on the public evidence.
Okay.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if we set this for a PSI, it's going to be about 8 weeks. If you would like, though, since the state is silent, I can reset this in a couple of weeks, and that'll give you time to have witnesses present if you want to call witnesses.
I'm fine, Judge. If you want to set it for, you get 3 or 4 weeks.
All right, Ms. Ferguson, I need a 3-week reset, please, on this case for sentencing, and there's no PSI.
That would be a June 10th.
All right, June 10th. All right, on June 10th, what will end up happening is I'll make a decision on your application on June 10th, okay? All right, once you sign the reset form, you're excused. You're welcome. Is there anyone else who's ready?
Denny Callahan, Judge.
I'm sorry, yes.
Get that list of people, either 3 or 4 people, okay? Get the list of 3 or 4 people that you want to tap. I'll just do that.
No problem. Vanessa Marivete.
Ready?
All right. Court is calling 2025 CR 0035530 State versus Vanessa Marivete. Can I have parties announced?
Attorney for the state of Texas.
Any count, I have the fence.
All right, and you are Miss Variant. Yes, all right. Counsel, you received all discovery. Did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Marivete, did you review the application for deferred adjudication with your attorney? Did you understand it and did you sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Your Honor.
Did you review the court admonishments with your attorney? All right, then they need to talk with Mr. Brown. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with injury to a child or disabled, elderly or disabled person bodily injury as a 3rd-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses? Do you believe she has a rational as well as a factual understanding of the charges against her? Do you believe she's currently competent and was legally sane at the time of the offense? Ms. Marivete, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is be assessed at 2 years in the prison. There's a $1,500 fine. State is silent on your applications. This will run concurrent with 2025 CC 0033873. There's an affirmative finding of family violence and no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your plea?
Yeah, amplify, Your Honor.
Yes.
Give her deferred adjudication. Parties are suggested to be in mental health supervision.
All right. But other than that, that's your plea bargain agreement, defense? State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions? Outside the agreement, there's a request for a mental health evaluation and follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence? Did you review the waiver and consent and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call on the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. What we can do, counsel, I can set it for a mental health evaluation. How long will that take just to do a MIC evaluation? Probation?
Judge, it's gonna be 3 weeks.
All right, so do you want the TAP as well, counselor, or just the mental health evaluation? All right, if we can do just a MIC evaluation,
Can I have the pause on, Judge?
it is 2025 CR 003-530.
Thank you.
All right, so what we'll do then. I'll set it for, I'll set it for June 12th. Is that enough time?
Yes, Judge.
All right, so you'll come back on June 12th and I'll make my decision at that time. All right, thank you. All right, are y'all ready? All right, Norma, and see if Judge Nahara can hear the bond matter Thank you so much for coming down. All right, so I need to take up this plea on Paul Diaz, and then everybody else. We'll see you all tomorrow. I don't know where yes.
She doesn't know Hatfield and his boys on it.
Oh my gosh, you don't know, you haven't heard about the Hatfields and the McCoys? Oh my gosh. Yes. Mr. Ross?
Yes.
Your attorney is not here. I don't know where your attorney is. Your attorney is not here in this courtroom. She was supposed to be back here at 1:30. She was supposed to be here at 9 a.m. this morning. She was not here at 9 a.m. this morning. And then she was supposed to be here at 1:30, and it's 3 o'clock and we have not seen her. So what's going to end up happening is we'll have you brought over tomorrow. And then council will take yours up.
days back, like 7 days. In this guy, you know. If this is okay.
Oh, okay, guys, I tell you what, to save you all time, I'll just ask the question again about
Okay.
any time constraints, so it won't come off of your time.
Can you ask us one more follow-up then?
But All right, everyone, please be seated. All right, ladies and gentlemen, thank you so much for your patience. I know that one of the jurors had a final question, so I'm going to ask this question for the last time. Now's your time. Is there anyone who has any type of time constraint other than the people that I've already talked to? All right. 6, I've already spoken to you.
Mentioned, daughter I share, the vision of with my wife.
Okay.
Both work from home, so I want her to watch certain things that what to do. Smash out.
All right. Thank you. Number 13.
My son is graduating in Tuesday.
That's Tuesday of next week.
Yes.
All right. Well, tell him I said congratulations. Number 10.
Ma'am, I feel like I didn't get to explain completely why I'm in a different state. I
Sure.
was going back and forth. I have business over there, so I was going back and forth. And I've been over there and not working is incredibly hard. Half of my staff is not working because I'm not there right now. My daughter, I had to fly her in.
So why are you here in Bear County?
I have a dental office, 2 dental offices in New Mexico in an underserved area, and I was also working here as a dentist. And since I didn't have a dentist to cover over there, I've been there for a year now. And I do agree that I need to change my residency. It just hasn't been a permanent thing until, I guess this has come up and it's become such an issue.
All right. Thank you. All right. Number 27.
I have a first sonogram for my girlfriend. She's pregnant. 7 weeks.
And when is the sonogram?
On Thursday,
What time?
I leave 3. I'm not too sure.
All right. How are you going to show up if you don't know what time?
Cause I'm off that day and she's gonna pick me up. And then Friday I have a graduation at 7 p.m. for her sister.
All right. Thank you. Number 34.
My fiance has multiple sclerosis. Usually I am there within her vicinity to make sure.
I'm
that
sorry, you said your fiance what?
She has multiple sclerosis.
Okay.
I need to be there in the event that she does have any types of flare-ups, such as potential blindness and paralysis. And then on top of that, the job that I'm working for, while it does cover, I work from home. While it does cover for me to come here and attend for jury duty, I do usually have to use my PTO, so going and attending from here until Friday would burn a lot of the amount that I don't have.
All right. Thank you. Number 45.
I have a social security appointment by phone I've been waiting for a month and a half.
Mhm.
I postpone it, not gonna get my benefits.
All right. And when is this?
Thursday.
What time?
I don't know, they said whatever time they call me.
Okay. All right. Thank you. Number 52.
My daughter here and she has, where they go to like elementary, and that's tomorrow at 10:45.
All right. Thank you. Number 55.
8:30 today at 5:30. This ceremony.
All right. Thank you. Number 56.
I cannot financially afford to be here any more days than today.
All right. Thank you. All right. With that being said, I am going to turn it over to the state.
I have a confession to make to all of you. So I want you to think back to early this morning when you were on your way downtown to the courthouse. I was probably on my way to work around the same time as you. And so it's no secret that there's a lot of construction going on downtown, but I'm used to it because I come down here every day for work. And so usually when I'm on my way to work, I'm, running ahead of time, and there's a lane on Cesar Chavez that it gets down to 1 lane. And so usually there's people that don't know about it and they're trying to merge at the last minute. And usually I'm like, we're all friends, come on. But this morning I was running a little behind and there was a car that was trying to merge, and I was like, I'm sorry, bud, but this morning I cannot let you merge because I have to get to work. And so I'm confessing this to you all because if you see me standing here and you say, hey, that's that jerk that didn't let me merge this morning, speak now or forever hold your peace. So Judge Boyd did talk to you all about this. She let you know the best kept secret in the courthouse. And that is that if you do not speak up during jury selection, your chances of ending up on the jury are exponentially higher than people that are going to speak out. And so I know you probably feel like, please, please, please don't call on me, but I am gonna have to start calling on you guys if I don't have any volunteers, because if you don't speak up, you are most likely going to end up impaneled, and look at how happy those people look to be sitting on the jury. Now I want to talk to you all about the purpose of jury selection. Now, the judge informed you that we can't talk about the facts of this specific case, and that is correct. During jury selection, we're going to be talking about the law that would apply to the charges that we're here for. This is our time together, and what I'm trying to do is learn about you all, because both sides, the state and the defense, are trying to find 12 fair and impartial jurors who are right for this case. Now, can anyone tell me who that is up on the screen? Okay, Willie Nelson. Good job to people that were going to take part of that. And what does Willie Nelson love?
Marijuana.
Marijuana, right? And so what kind of case do you think that he would be not a good juror on? A possession of marijuana case, right? And so this is kind of going back to what the judge was talking about the burglary case, but I'm going to refer to something that I call the Willie rule. And the reason that Willie Nelson would be a bad juror on a possession of marijuana case is because he fundamentally disagrees with the law, and he believes that marijuana possession should not be illegal, and that's his right. He can believe that, but right, what I'm trying to figure out is if any of you have any fundamental disagreements with the law. And so I will refer back to this Willie rule. And what I'm talking about here, it's a 3-part inquiry, right? Do you understand the law? Do you agree or disagree with it? And if you disagree with it, can you still follow the law that you received from the court? Does everybody understand that? Yes. Now, I have a rule in my jury selection presentation, and that is no waffling, okay? We only have 30 minutes with each other. That's not a long time. And sometimes during jury selection, I'll ask a question and it's a yes or no question, and we get jurors and they're like, well, I think I can. They're kind of like the little engine that could. And I'm sorry to inform you, but that's not good enough. So I'm just asking you to listen to the questions that I'm asking you and try to identify on which side fits you best. Does everybody understand that?
Yeah.
Now, the judge let you know that the burden of proof in criminal cases is beyond a reasonable doubt. What does that mean? So there is no legal definition. She let you know that, but I can't tell you what it is, but I can tell you what it's not, right? And it's not beyond all doubt. It's not beyond a shadow of a doubt. And it doesn't mean that you're 100% sure. Does anybody know what that would make you if you were 100% sure about what happened on the night of the offense?
Witness.
A witness, yes. Good job. Usually we only get like one person that knows the answer to that. But I want to use a hypothetical to explain the concept to you. So, juror number 3. Do you own any pets? Pets? No. Who's a pet owner in here? Okay. Juror number 4, I'm going to pick on you. Have you ever come home to this before?
Yes.
Yes. And so if you look at the picture, can you tell me what happened or what you think happened?
Well, the dog looks guilty because he went into the trash and made a mess.
Right. And so we can tell that from the facts and circumstances that are surrounding the evidence, which is the photograph here, right? The dog is looking at the photographer. He's standing by the trash, and you can see that it's all disheveled. So the way that I explain this concept is, in this instance, right, is it possible that somebody went into the home, broke in the home without consent, and just toppled the trash over, but there's no signs of forced entry. There's no fingerprints or anything to indicate that anybody else was there. And there's nothing that was taken from the home. It's possible but that's not reasonable. And in these cases, we have to look at what the evidence suggests. Okay, does everybody understand that?
Yes.
Now, knowing that the standard is beyond a reasonable doubt and that the concept, as I've just explained it, is there anyone here that says, I think that the burden on the state should be higher and I'm going to require the state to prove their case 100%? So beyond that, beyond a reasonable doubt. Is anybody here going to hold the state to a higher burden? If you are, raise your card. Okay. Now I have this question. I'm going to explain it to you all, but it's a ranking question. So I'm going to ask you to raise your cards. And the question is, what is your opinion of the criminal justice system? So the first choice is you think it's terrible and it takes away the rights of citizens. 2, you think it's concerning because it interferes with our rights. 3, you think it's helpful because it looks out for citizens. Or 4, you find it beneficial because it protects us from the harmful actions of others. So do I have anyone who identifies most with choice 1, they believe that it's terrible? Okay, what about choice 2? You believe that it's concerning? Please raise your card. Okay, juror 10, 11, 26, 27, 30, 31, 34, 40, 41, 42, 52, and 56, 57, 61 through 64, 68, and 71. Okay, you can put your card down as soon as I call your number. I'm going to skip over 3. And then who identifies most with choice number 4? They believe that it's beneficial and protects us from the harmful actions of others. Juror 2, 3, 8, 12 through 14, 15, 16, 18 through 21, 23, 29, 36, 38, 39, 43, 47, 51, 54, 55, 58, 60, 65 through 67, 69, 70, 73, and 75. Okay. So there's something in criminal cases. The judge talked to you about the indictment. It is not any evidence of guilt. It's just the charging instrument. There is such a thing called a multi-count indictment, and that's what the judge said. There is 2 charges. Basically, it's just the criminal conduct that we're concerned with meets 2 different chapters of the code, and so I just wanted to explain that to y'all. So count 1 is aggravated assault with a deadly weapon. If you look on the screen, these are the elements that we would have to prove beyond a reasonable doubt. So the judge did mention some of them on or about the offense state in Bexar County, the defendant, and then we'll talk about mental states. So did intentionally or knowingly threaten imminent bodily injury to the victim and did use and exhibit a deadly weapon that in the manner of its use and intended use is capable of causing death or serious bodily injury. That's a lot of legal terms and we'll talk about them later. Count 2 is injury to an elderly. The elements are on or about the offense state in Bexar County. The defendant intentionally, knowingly, or recklessly caused bodily injury to the complainant, and the complainant was 65 years of age or older. Now, the mental states intentionally means that it's the defendant's conscious, objective, or desire. So what I think about when I think about that is, did they mean to do what they did? Knowingly is defined as the defendant is aware of the nature of his conduct. And so when I think about that, I think about, did they know what they were doing when they did that and do it anyway? And recklessly is defined as a conscious disregard of a substantial and unjustifiable risk. So what I think about when I think about that is, did you know that there was a big risk that the result could happen and you did it anyway? So regarding the mental state, the law says that you are not required to be a mind reader. You can infer the defendant's intent from the actions, words, circumstances, and facts that surround the case. And so we're going to explore this with a hypothetical from my favorite movie, The Titanic. And so there's 3, if you haven't seen The Titanic, don't worry, I'm going to tell you everything you need to know to understand the hypothetical. But there's three players in play here. So the first is Cal Hockley, the second is Rose DeWitt Bucator, and the third is Jack Dawson. And so we're going to look at the circumstances to determine Cal Hockley's intent. And so these are the facts. Cal grabs a firearm from his personal attendant. Cal starts shooting at Jack and Rose. There are many other people that are in the crosshairs, and Cal chases Jack and Rose without regard for the bystanders and continues to shoot at Jack and Rose until the magazine runs out of bullets. Juror number 1, what do you believe that Cal's desire was in that hypothetical? To shoot them? Okay. Juror number 2, what do you think Cal should know was reasonably certain to occur, him discharging the firearm at Rose and Jack? He could kill them, right? And juror number 5, what is a substantial and unjustifiable risk that Cal is disregarding?
I'm
He could-
sorry, if you could speak up.
Sorry. That Cal could potentially hit bystanders in the crossfire.
Yes, he could hit the bystanders. Very good. So does everybody understand that concept? Does anybody have any questions? Okay. So moving on, I have this and it says, if someone's thinking, well, Rose and Jack did not get hit, is this still an aggravated assault with a deadly weapon? It is, right? Because aggravated assault with a deadly weapon is defined of the threat of imminent bodily injury, which everybody knows if a firearm is discharged, you could get seriously injured. And then the deadly weapon, which we'll talk about that in a little bit. Imminent is just defined as near at hand or impending, and bodily injury at a minimum is just physical pain, okay? So talking about deadly weapons, firearms are per se deadly weapons, but really anything could be a deadly weapon. And the definition for deadly weapon is anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. So the example that I like to give for this is a pillow, right? And let's think about 2 college roommates that are living with each other in a dorm room. If one college roommate takes a pillow and hits their roommate, is that a deadly weapon in that instance?
No.
No. But if that roommate took the pillow and suffocated the roommate, is the pillow a deadly weapon in that instance?
Yes.
Does everyone agree with that?
Yes.
Okay, does anybody disagree with that? No. So my question for you all is a motor vehicle capable of causing serious bodily injury or death? Yes. Okay, and how do we know that, right? It's an important issue for TxDOT. If you're out driving on the roads, you see their buckle up, don't drink and drive, right? And all you have to do is turn on the TV and see the casualties that are caused by motor vehicles daily, right? And so I have a question for you all. What are some driving behaviors that can lead to bodily injury to another? So like if you're driving in a car, what are some factors that could contribute to you causing bodily injury to somebody else? Juror number 10.
Be distracted.
Distracted. Who else had her? 28.
Text messaging, calling, drunk driving.
Texting. You said texting,
Drunk driving.
drunk driving. Very
All right,
good.
everyone, remember to stand.
Driving under the influence of drugs.
Okay, driving under the influence. 33.
Aggressive driving.
Aggressive driving, very good. 42.
You're tired or sleepy.
Tired or sleepy. 44.
Texting.
Texting. Okay, 67.
Speeding.
Speeding, very good. Yeah, so these are all right. Speeding, not paying attention, not looking in the mirrors that you're supposed to be looking at, distracted, and not adhering to the traffic code, right? So I have this question and it says, what type of evidence would you expect to see in an aggravated assault with deadly weapon case? So I'm gonna pick on you. What's your card?
8.
Number 8? Okay.
Sorry.
Do you have any idea of the type of evidence you'd expect to see in this case?
I'd expect to see what the weapon is.
What the weapon is? Okay. Juror number 9. Do you have any idea of some evidence you'd like to see?
Photos of the scene.
Photos? Okay. How about, what's your number, sir? 15. Do you have any idea of some evidence you'd like to see? Oh, some camera footage? Okay. So I asked this question because testimony is evidence. So most of the evidence that you will hear in any criminal trial will come from the witness stand and the witnesses that are testifying. And so you could hear from a host of different witnesses. You could hear from police officers, civilians, even the defendant, or any witnesses that they choose to call. Regarding witnesses, you're the exclusive judges of the facts proven, the credibility of the witnesses, and the weight to be given to the testimony. Does anybody have an idea of why you would not hear from a certain witness or victim in a case? Yeah, what's your number?
30, retaliation.
30, retaliation. What is your number? 12. Do you have an answer? Not wanting to be known. Juror number 7. I'm sorry. Oh, if they're too young, okay. Sir, what's your number?
13.
13. Do you have an answer? No? Okay. Sir, what's your number? 18. Do you have an idea why you didn't hear from a witness in a case?
It could perhaps be self-incriminating.
From a witness. Okay. 28.
They're a non-credible witness because of something they've done in the past.
Okay. 67.
Bias.
Okay. 69. Did you have your card race? 68.
They're frightened.
They're afraid, right?
Yeah.
So there are many different reasons why, sorry, did you? Okay. There are many different reasons why you wouldn't hear from a potential victim or witness in a case, right? They could be scared, they could be unavailable, they could have passed away. But is there anyone here that thinks that the DA's office should not proceed on cases where the complainant or victim is unavailable? Yep. You understand what I'm asking? No, him.
Asking why victim unavailable, I mean that perhaps the victim is deceased.
No, so I'm thinking, so let's say that the victim is just unavailable and we don't know why, right? Maybe we don't.
Yes. Yes.
The different reasons why a victim or witness would be unavailable. And so my question to you all is, are you going to hold it against the state if the victim is unavailable for whatever reason? And when you think about this concept, I want you to think about hypothetically, like a murder case, right? There's a deceased victim in a murder case. The state still has to go without the complaining witness. Does everyone understand that?
Yeah.
And so in a different case, like in an aggravated assault, there is no death alleged, right? Because that would be murder. But sometimes there are issues with witnesses and maybe they wouldn't be able to come and testify. So is anybody here going to hold it against the state if we're unable to provide the victim or any witness in a case? You would? Juror number 10. Yeah, if you would, please raise your card. Juror number 7, 10, 27, 34, 40, 52, 56, 59, 71, 72, and 73. All right, thank you. All right. Now, when you receive the law from the court, does anybody know what movie this is? Mulan. Okay, I'm sure you know from your daughter, right? And so the reason that I have this up here is because this scene specifically, she's singing a song called Reflection. And so when you receive the law from the court, if you are chosen to be on the jury, you will be instructed that you cannot let any sympathy play a part in your deliberation. And so the reason that I bring that up is because sometimes, what does a defendant look like? It could look like anyone, right? It could look like any one of us in this room. or somebody that we know and love and care about, our parents, our brothers, sisters, cousins, right? But you are gonna receive the law from the court saying that you cannot let sympathy play into your deliberations. And so my question to you all, is there anybody here who would be unable to set aside any sympathy that they felt for the defendant in the case? Everybody could set aside their personal sympathy and render a verdict according to law. 56, you would be unable to set your sympathy aside?
I can't 100% say every time, yeah.
So I'm gonna refer back. I need a yes or no, but if you just raise your card, please raise them up. Okay, 23, I'm gonna start with you. Would you be able to set sympathy aside in this case? You would not. Okay, thank you. You can be seated. 52.
No.
You would not be able to set your sympathy aside. Thank you. 44. You would not be able to set it aside. Thank you. 54. Would you be able to set it aside? Okay, thank you. 56. Would you be able to set it aside?
No.
41. Would you be able to set it aside? I need a yes or no.
No.
Thank you. 72. Would you be able to set it aside?
No.
Okay. Anybody else? 10. You would not be able. Thank you. So I have this ranking question that I want everyone to answer, and it is, what is your opinion of law enforcement in Bexar County? 1 is being you have a less than favorable view of them. 2 is a step up from that. 3 is you have a favorable opinion, and 4 is you have a very favorable opinion of law enforcement. So I'm going to start with number 1. Who here has a less than favorable view of law enforcement in Bexar County? 72 and 27. Okay, choice number 2. 5, 7, 17, 19, 21, 23, 33, 34, 40, 41, 42, 46, 52, 56, 57, 59, 61, 62, 63, 64, and 74, and 17. Okay, so of you all that just had your cards raised, I'm gonna have you raise them again. And so I'm gonna start with juror number 5. Would your less than favorable view of law enforcement affect your verdict in the case, or would you be able to set it aside and evaluate the officers that testify in this case and make a fair and impartial decision? You would not be able to. Okay, you would, okay, thank you. 12, would you be able to set aside your less than favorable view? Okay, thank you. 15, you would not be able to set it aside. Sorry, you have to speak for.
No.
Okay, thank you. Okay, would you be able to set it aside?
Yes.
Okay, thank you. 19, would you be able to set it aside and judge the witnesses in this case?
Yes.
Okay, 21, would you be able to set it aside and judge the witnesses? In
No.
this case? 23, same question. Would you be able to set it aside and judge the witnesses in this particular case? Yes. 33, would you be able to set it aside and judge the witnesses in this case? Yes. Okay. 34, same question.
Yes.
40,
Yes.
41. Yes.
Yes.
Okay. 42.
No.
Okay. 46. 52.
Yes.
56.
No.
57.
No.
59.
Yes.
61.
Yes.
62. 63.
Yes.
64.
Yes.
And 74.
Yes.
Thank you. So as the judge explained, there are 2 phases of the trial. And guilt innocence, you are deciding whether or not the defendant committed the offenses that they're charged with. And punishment, you get to look at a lot more. And so regarding punishment, the judge has already explained the range of punishment to you. So count 1 is a second-degree felony from anywhere from probation to 20 years in prison. And count 3 is a third-degree felony, which is anywhere from probation to 10 years in prison. And so really what we want you all, as a judge explained, to do is keep an open mind and be able to consider the minimum and the maximum. And so right now, having heard 0 evidence, your answer should be, yes, I can keep an open mind, right? We're all on the same page about that.
Yes.
5 minutes.
Thank you, Judge. So in sentencing, like I said, you can see a lot of different evidence, whether they've committed acts like this previously or subsequently, character evidence and other things like that. So I do have one last question for you. And it's, what is the main purpose of sentencing in your opinion? So basically I'm asking you, what do you most identify with in your punishment theory? Do you think that it's punishment, deterrence, making amends, or rehabilitation? So if you feel like it's punishment, please raise your card. Okay, that is 1, 2, 8, well, 5 through 7, 8 through 13, 15, 18 through 20, 23 through 26, 34 through 36, 38, 39, 42, 44, 45, 47, 49, 50, 51, 52, 54, 55, 56, 57, 59, 61, 71, 72, 73, and 74. I'm just gonna move on from that because I'm running out of time. Does anybody here have a family member or somebody that they know or care about? And you don't have to get into specifics, but does anybody here know somebody that they feel fondly for that had an encounter with the criminal justice system and they felt like they just didn't get a fair shake in their circumstances? So my question to you all is, would you be able, you can keep your card up, please. And my question to you all is, would you all be able to set aside that, or would it weigh in your deliberations? Okay, so I'm going to start with juror number 9. Would you be able to set that aside and render a fair verdict in this case? Yes? Okay, juror number 10. It would weigh, so no. Okay, 11.
Yeah.
You can set it aside. Thank you. Juror number 7. Can set it aside. 17.
Yes.
You can set it aside. 21.
No.
Thank you. 40. 44. You cannot. Okay. 52.
Yes.
54.
Yes.
55. 56.
No.
70.
Yes.
72.
No.
75.
Yes.
Thank you. And I'm just gonna ask again one last time, is there anyone here that for whatever reason, personal, moral, or religious, you feel like you cannot sit in judgment of another person? 72 and 74. And 41 and 42. Judge Shahab?
1 minute.
I'm gonna go back to this question. If you feel that you are more rehabilitation focused on punishment, can you please raise your card? 4, 21, 28, 37, 40, 41, 63, 64, and 68, and 70. All right. Thank you all so much.
All right, defense, you may proceed.
Good afternoon. My name is William Davidson, and I represent Darren Johnson. And Robert Porter is here to assist as well. I'm going to go over a few concepts that the judge has already been over and the state has already been over, because some of these concepts apparently are not always clearly understood, even though you might see them on TV. And this came to me very clearly about a month ago when I was in a DWI trial. And the person was found guilty, but when I went back and talked to the jury, I was very surprised what they told me. They said, well, we had to find him guilty because he didn't testify. You didn't put on any witnesses. You cross-examined the state's witnesses, but you didn't put on any witnesses. That's second cheese, you know? The judge spent an hour talking to him about that. The state talked about that. I talked about that. And so I need to make sure that you understand that if somebody's accused of a crime, they don't have to get up there and testify. I get it that most people would like to hear from them, but they don't have to. So if you think you would find my client guilty because if she decides not to testify, it's her choice, not mine. You find her guilty anyway, can you please, and this is not a wrong answer, it's just you're not right for this jury. If that's the case, please raise your number. 59, okay. 10, 17. Okay, so the next question I'm going to ask those who raised their number is the same question the state asked you. And that's that, my question was a little bit more severe. I said, would you find my client guilty? But the state would also ask you probably was, can you put that aside? And so I want to see your numbers if you can't put that aside. If you can't put that aside and you say, okay, she's guilty because she may not testify, please raise your number. 1744. And the others here that raised your number, 27. And I'm assuming those that raised your number 10. Is your hand still raised? Okay, all right. Thank you. Thank you very much. So there is, as the judge told you, a presumption of innocence. As my client sits here, you haven't heard any evidence in the case. Sometimes people say, well, they must have done something, they're up here. But juries find people guilty and not guilty every day. And there are different standards of proof. The proof that we're looking at here is beyond a reasonable doubt. And there's other standards. There's standards the judge talked about. For example, if I were to stand in the middle of this room and put my hands out, would be, preponderance of the evidence, one way or the other. That's done every day on motions to revoke probation. It's also done on the civil side. But if the state proves their case 59%, does that mean my client's guilty? Yes or no?
No.
No, right. So preponderance of the evidence. There's lower standards. There's no evidence. There's scintillative evidence. There's reasonable suspicion. Reasonable suspicion is when a cop pulls you over. Does that mean you're guilty? No. Probable cause. Now a cop can pull you over and you see something he thinks in your car is drugs, maybe it's sugar. He arrests you. But does that mean you're guilty?
No.
No, absolutely not. Judge was also talking about clear and convincing evidence, about the evidence needed for the state to take away your children. Should that be high or low? High. Now, if that's the standard that they reached, can my client be found guilty?
No.
No, beyond a reasonable doubt. We don't have a firm definition anymore, but you have to decide what it is. In every trial I'm in, the state always shows these really easy examples. Everything is wet, it rained, the dog went into the trash, the ball came out on the field, little boy's running after it. But if it was really that easy, would you be here? No, no. It's not that easy. It's not that easy. And I thank all of you for being here and for those who are going to be on this jury, because it's not easy to be on the jury or to sit here for however long it takes and listen to the testimony. I do have a few questions based on some answers that people raise their hand or not, and also some questions that are just very brief about these jury questionnaires that some of y'all filled out. I'm going to use the numbers, and the reason I'm doing that, the numbers do correlate with names, but some of these last names I might have a difficulty pronouncing. Do I have your permission to use the numbers? Yes. Thank you. Thank you. Okay, so number 2, I believe that you put that you were retired. And what did you retire from?
Medical insurance.
Medical insurance. Thank you very much. And number 39. Yes. Are you retired as well?
Yes.
And what did you retire from? Thank you. Thank you. Thank you. And what did you teach? Oh, thank you. And number 8, I believe you said you had some relatives that were law enforcement officers. Is that correct?
I do.
Do you see that as affecting the case in any way, or can you just listen to the evidence and come to a verdict, or how?
I'm a law enforcement officer and I can listen to the evidence.
You can listen to the evidence, and where are you a law enforcement officer at? San Antonio. Police Department, Sheriff?
I'm the FBI agent.
FBI, okay, well, that's even more interesting. Thank you. Now, there's some here that put, you want a criminal jury trial. And so number 2, I just have to ask you this question. Did the judge or the jury assess punishment? The judge did, okay. Number 9? Yes. Did the judge or the jury assess punishment in that case?
The judge.
The judge, okay. Number 11. And you were on a criminal trial? On the jury?
Yeah.
You weren't, okay.
Okay, well, I'm sorry about that.
No, that's okay. I wrote it down, my mistake. 39. The judge assessed punishment, thank you. 43,
The jury.
the jury. 49. Were you on a criminal? Yes,
Maybe 20 years ago, I looked at here,
do you recall if the judge or the jury assessed punishment?
jury. He was. I think the term was acquitted.
Acquitted, if I'm not guilty, okay, thank you. And 58? 58,
The judge.
the judge, okay, thank you very much, appreciate it. Now, there's something else I wanted to go into, and that's culpable mental state. The state talked briefly about this, intentionally, knowingly, recklessly. Recklessly is aware, you're aware of a situation, you do it anyway. But below that is criminal negligence, meaning you ought to be aware. And these are slightly different, but they might make a big difference when it comes to when you look at the instructions that the judge gives you on finding this person guilty or not guilty. And that also goes to something the state just said, that there's two phases of a trial. What the judge said is maybe. When is there one phase of the trial?
When it's not guilty.
When it's not guilty. And when are the two phases? Guilty, okay. Now, is there a guilt innocence phase? Can you ever find somebody completely innocent? You've heard all the evidence and you know 100% they didn't do it. No. So there is no guilt innocence phase. There's a guilt not guilty. Not guilty means the state has not proven their case beyond a reasonable doubt. Guilty means they have. Everybody understand that?
Yes.
Yes, thank you. Just a minute, please. I'm going to talk about the last thing here is a deadly weapon. So this is a space pen. Does everybody know what a space pen is? Yeah. I really like them because they're pressurized and they write upside down or write all the time. They don't just give these big blots like most pens. But is a space pen or any pen a deadly weapon?
Yes.
Is it automatically a deadly weapon?
No.
If I'm writing on this piece of paper, is it a deadly weapon?
No.
If I'm stabbing somebody in the eye with it? Yeah, okay. In a similar way, when you're driving down the freeway, all those cars that are passing you or you're passing other cars, do you necessarily think of each and every car as a deadly weapon? No. What about when you're driving along and somebody passes you and they're weaving in and out? Absolutely. There you go. So it's context specific, and you, the jury, decide that. The jury decided that based on the facts of the case. Thank you very much.
All right, ladies and gentlemen, I am going to have you step outside. You're not excused. Make sure you take your items with you though, and then we'll call you back in and you will know if you are on the jury or not. Everyone, please rise for the jurors.